Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we're going to talk about a partnership that operated an insolvency practice. An insolvency practice, for our purposes today, is a business whose principals engaged in accepting appointments as bankruptcy trustees and liquidators. So they'd help with insolvent estates and insolvent companies, liquidating them, and they would take the corpus of that, they'd be paid from that, and that's how they would generate funds and fees and indeed profits for the company, for the company was profitable. Now, in about September 2014, a party who we're going to call A elected to end the partnership, and after the end of the partnership, A marched on with the lion's share of the administrations, the lion's share of the various appointments as bankruptcy trustee and liquidator that were previously the property of the partnership. Now, I'll have a sip of this first. A number of pieces of litigation followed, as you might expect, arising from this situation. And we're not going to comment on all of them. We're going to comment on one fairly niche element of them that related to the taking and the passing of partnership accounts. And the taking of a partnership account essentially means that at the end of the partnership, you want to figure out what the assets are and you want to make sure that they're evenly distributed or appropriately distributed between the partners. You know, you account for your expenses, you account for your assets and all these sorts of things. And the big argument we're dealing with today was what A said about the partnership's book. The partnership's book of business, what we might loosely think of as client base, although in relation to an insolvency practice, a client base isn't quite what we're talking about. But all of those appointments as liquidator of companies A, B and C, and all of those appointments as bankruptcy trustee of the bankruptcy estate of Ms. A, Ms. B, Ms. C. So all of these appointments, what is their value? What is the value of that book as at the time of the end of the partnership? Now what A says is that that book of business, that book is actually a liability. And so what that means is the value of the book is going to reduce the value of the partnership as at the date when the partnership ended. And what R says, and A stands for appellant, R stands for respondent, so you know where we're going here. What R says is, that is not in fact the case. What we say is the book of business is not a liability, it is an asset of the partnership, and so it should be counted as an asset of the partnership for the sake of the taking of these partnership accounts. Now, this dispute comes before a primary judge. What the primary judge does, in effect, is fine for R. Primary judge says, in effect, no, it's not a liability, like A said. It is, in fact, an asset, like R said. And there are a number of reasons for that. A's argument that the partnership book of business was a liability turned on a number of things. One of those things was the likelihood any hypothetical purchaser of a hypothetical book of business would want a discount. They'd want some payment to be induced to complete the purchase of this book of business. And if we're reading between the lines and sort of understanding the nature of that industry fairly well, that discount or that payment or inducement might be thought of as some way to set off against the risks that a purchaser might assume. Because, as some of you may know, the administration of a bankrupt estate or the conduct of a liquidation might give rise to some risks personally for the bankruptcy trustee or for the liquidator themselves. And so, what is suggested by A's experts, as A's experts try to assist the court in concluding that the partnership book of business was a liability, is the suggestion that any purchaser of the partnership's book of business would be seeking a discount, would be seeking some sort of reduction or potentially some sort of payment to themselves on account of assuming the risks of the administration of company A, B and C and Ms. A, B and C on account of their bankrupt estates. So there was a suggestion of this discount being appropriate. Now, the primary judge was not particularly interested in that argument and indeed was not particularly interested in the evidence put forward by the appellant's experts at all. And so, because you heard the name of the party was the appellant, what you might correctly have inferred from that is that an appeal flowed from there. Now, the nature of that appeal was the appellant said, in short, the primary judge was wrong, And the primary judge was wrong to find that the partnership book was an asset instead of a liability. They were wrong because they were wrong to conclude that the discount would not have applied to any value. And they were wrong for a number of other reasons, wrong to not accept the expert evidence, wrong on a number of bases. And we're going to come to what the Court of Appeal says about that in a moment. So the Court of Appeal is forced to consider each of these various grounds for, in essence, criticism that the appellant raises in relation to what the primary judge found. The short point is the appellant loses the appeal because the Court of Appeal upholds what the primary judge said, remembering that the primary judge said the partnership's book of business was an asset, not a liability. And so why does the appellant go down on the appeal? Now this is fairly technical, so hold hands with me as we try to understand this together. One of the reasons, and one of the fundamental reasons, is the professional obligations that attach to the conduct of an insolvent or a bankrupt estate or a liquidation in insolvency. Now, what the relevant rules that attach to insolvency practitioners say is that an insolvency practitioner cannot pay or accept an inducement, an additional payment on the taking on of a new matter or the transfer to them of an administration. And so the suggestion that any purchaser would enjoy a discount or some payment or inducement or of some kind was completely inappropriate because it was going to be impossible for the vendor to pass that payment on while sticking with their professional obligations. And so what the court says is, well, the professional obligations apply. That means no discount can be paid, and that means no valuation can bear a discount in mind. There was another challenge that the Court of Appeal found fundamental to the nature of the appellant's appeal and fundamental in disposing of it, was the failure of the appellant's experts for engaging with the possibility that a liquidator or a bankruptcy trustee, potentially in the position of A or R at the time of the end of the partnership, might accept the opportunity or pursue the opportunity to resign from their appointments, right? So the suggestion they might have to pay someone else to take on these appointments sort of falls away because the court finds it's, well, why are you going to pay someone else to take on these appointments when for paying $0 in effect, you can simply resign from your position and it becomes more or less the court's problem to go and appoint someone else. So what the court finds is, because it would be a breach of the professional obligations of the insolvency practitioner, and because, in essence, the financial incentive doesn't arise because, as the appellant's experts fail to consider, it's always open to the insolvency practitioner to simply resign, the court says that the discounts that are argued for by the appellants to say, look at all these discounts, as a result of them, the partnership's book of business is actually a liability and not an asset. The court says, for those reasons I've just explained, that in fact the book of business is indeed an asset, that a discount would not apply on sale, and that the valuation and the passing of the partnership accounts has to take place on the basis that a discount is not available. And so the appellant's appeal fails, the respondent's response, and there's a notice of contention filed where they make some of their own arguments, succeeds. A little bit fiddly today. I hope that discussion assisted you in understanding a fairly fine and technical dispute, and I look forward to joining you again soon over another coffee and in respect of another case note. Cheers.